This meeting to order. Welcome to the 25th meeting of the Standing Committee on Procedure and House Affairs. We're meeting today to continue our work.
Take two. The committee is meeting today to consider Bill C-14 for the first half of the meeting, and I would like to welcome the following witness. Nous avons avec nous aujourd'hui le professeur Patrick.
We have with us today Professor Patrick Taillon, tenured professor constitutional law, University Laval. So welcome, Mr. Taillon. You have 5 minutes.
This committee for this invitation. Le projet de loi C-14.
Bill C-14, which amends the Constitution Act of 1867, is a clever bill which papers over the decline in Quebec's political weight, and it hides it behind a freeze of seats in the House of Commons. C-14 will increase this decline. Without C-14, Quebec's political weight in the House of Commons would go from 23.07% to 22.8%. With C-14, Quebec's political weight in the House of Commons would move from 23.1% to 22.5%. So the difference is approximately 1/3 of 1% of Quebec's political weight. We shouldn't confuse a reduction of seats, which C-14 avoids, and a reduction in Quebec's political weight, and C-14 enshrines this, makes it official. For some, this decline in Quebec's political weight is inevitable, and for others, and I am one of them, I think that there is a way to look at this in other ways. I think that the cause of the problem is complex because there is a fact, and that is Quebec's demographic weight in the Confederation is declining and has done almost continuously since 1967, but the causes for that decline are many. Some of them are perhaps Quebec's political choices, but one of the other causes of Quebec's political weight in the Confederation is, well, we have to know whether the federal government has more to do with the problem of this decline or can have something to do with the solution. The problem is especially important as this decline will become even more dramatic in the coming years. At the present time, the actual government is trying to increase our population. It has doubled immigration thresholds. We had 240,000 immigrants a year, and we will be moving to 430,000. So Quebec's present policy is to choose between maintaining its political weight by following Canada in terms of immigration, or to cultivate its ability to integrate people to become a crucible of immigration, but perhaps with lower immigration levels. At the present time, the question of the electoral map and Quebec's political weight has to be looked at in a more general way. It's a very sensitive question, which bears on the very nature of the pact which since 1867 has united Quebec within the Federation. So what can Quebec do to maintain its political weight? Because we could act in the House of Commons, we could also act elsewhere on several fronts. We could do more or we could do less. There's also the question of knowing what the government can do to increase Quebec's ability to follow to have a demographic level more like the rest of Canada. Now, this goes beyond the specific issue of C14, but even in the specific issue of the electoral map, the federal government could do better than a simple freezing of the number of seats per province. Quebec is a nation, and this was enshrined in a resolution in the House of Commons. The Supreme Court of Canada, in a 2014 decision, recognized Quebec's specific national nature, and this recognized Quebec's recognition within the Federation. It is written in black and white in the Canadian Constitution since the adoption of Section 90, which was added to the Constitution Act, and it states that Quebec is a nation. A bill like Bill C-14 would amend explicitly the text of the Constitution Act. There are facets of the makeup of the House of Commons which are not changeable by C-14. The principle of proportional representation cannot be amended except with the consent of 7% of 7 provinces. As for rep by pop, proportional representation, it is a rule. A constitutional objective, which, like others, is not absolute. It can be subject to accommodations and reasonable limits. The Supreme Court of Canada has, on many occasions, interpreted rep by pop as not being a purely mathematical idea. It says that within each province, there is room to tolerate certain. Mr. Taillon, I'm sorry, but we're now at 6.5 minutes. We were giving you 5 minutes, but you can share your time with any of the members of this committee, but we'll now go to questions. Is that all right? No problem. I understand. Thank you very much. We'll begin with the 6-minute round. Let's begin with Mr. Kamich, followed by Mr. Fergus and Mr. Terrien, and then Ms. Blaney. Mr. Kamich, 6 minutes.
Merci, Madame la Présidente. Donc...
Thank you, Madam Chair. And I'd like Mr. Taillon to continue dealing with this leeway within the legislation. I will give him a few minutes, and then I have a question to ask him about the demographic decline, because as a member from Western Canada, I care about this question. Well, the leeway that is recognized in the jurisdiction allows for certain differences, even within provinces. For example, the representatives of a city versus a rural region. But in its rulings, the Supreme Court has shown that this is not a mathematical imperative. It's not some sort of arithmetics. In practice, in our legislation, in the text of the Constitution, there are some exceptions to rep by pop. There's Senate representation, the fact that a province has a right to at least as many members of parliament as it does senators. This has been protected very explicitly in Section 41. But there's also an equivalent clause having to do with the territories. And this on no other basis than it being decided by the federal government. So we have rep by pop for the territories, and this can be changed in the same way we could change the electoral map and electoral representation. In the House of Commons, there have been many exceptions. There is a certain logic. It's not rep by pop, but it looks at distribution of seats. And I'm looking at the example of when Newfoundland joined Confederation, it didn't count. The seats in Newfoundland didn't count among the maritime seats in the House of Commons. Now, they say certain things are difficult to enshrine in legislation in the Constitution, but there are things that can be amended. It was done so for the territories for Newfoundland. So we shouldn't look at this rep by pop principle as an absolute, as if it were the only constitutional basis in this very delicate issue. So, Mr. Taillon, I'd like to ask you, the last time a province lost seats in the House of Commons was in 1966 when Nova Scotia, Manitoba, and Saskatchewan, I believe, lost seats. Now, why is it the Canadians in the West, Albertans, why should they be less well represented in the House of Commons now than they were in 1967? As you said, we have a far bigger population. We have immigration. But like other countries, we're no longer a small ex-colony. We're a great country in North America. So why do you think that Western Canadians should be less well represented in the House of Commons? Well, Western Canadians have concerns as well. There's the representation in Parliament. I believe that the number of seats for the Western provinces in the Senate is something that is a subject of concern, very legitimate concern. But this country, from time to time, needs to be able to have a true debate, a true discussion about where we started and where we're going. And the question of Quebec's demographic weight, or Quebec's weight in the House of Commons, as is the case with maritime provinces' political weight in the House of Commons, is something that's not only an issue of the electoral map. We can improve representation by working first on consolidating representation in the Senate and in the House of Commons. But to deal with the issue as being only a matter of freezing seats, where there's an overall increase in seats, it's a clever move, but it avoids the debate which we cannot forego. We need to have this debate. The concerns of the West can be discussed. Quebec's concerns about its demographic decline, which has been increasing since 1967. This needs to be also the subject of a great debate.
35 seconds.
Oh, Monsieur Taillon, donc j'allais vite vous demander d'abord.
Mr. Taillon, what are the other options about that would help us make sure that the other provinces are properly represented in Confederation? Well, we have Senate representation. Senators are appointed by the federal government. Tomorrow morning, they could have better representatives of provincial interests if the prime ministers or the prime minister accepted candidacies that are recommended by the provinces. These candidates would, for Quebec, would be recommended through its National Assembly, and then the decline in Quebec's political weight could be compensated for by the presence of representatives in the Senate who would be directly connected and responsible to the province, to the Quebec government. Now, this is an example of how we could provincialize representation in the federal parliament. And this would hold for prairie provinces as it would for Quebec. everyone would win.
Je vais juste rappeler.
Thank you very much. I'd like to remind you all that all members' comments should be put through the chair. Mr. Fergus, 6 minutes. Thank you, Madam Chair. And through you, Madam Chair, I'd like to welcome Professor Taillon. It's been at least 20 years, if not more, that I've been reading his many articles in various publications in Quebec, in newspapers, in magazines. I am an admirer of his thought. I don't always agree with his conclusions, but Professor Taillon, through you, Madam Chair, I must admit that here again, I don't always agree with everything he says. But what he says certainly merits study. And there may be some potential solutions to our situation. I'd like to thank the professor for his comments and his statement. Bill C-14 is certainly an option, an alternative that I think is more desirable than going with pure rep by pop, because otherwise Quebec would lose a significant amount of its political weight. Now, this C-14 is what we're studying today. But if we're to go by demographic projections, Madam Chair, it's clear that other provinces in the country in the next readjustment of the electoral map, there are other provinces that will have to deal with the same situation as Quebec. I'd like to ask this question. Professor Taillon, you said that the causes of the problem are complex and many, and I agree. Now, the issue of immigration. You mentioned that Quebec has a certain ability to integrate and to francisize immigrants of the economic class, but I come from a region in Quebec where we are the second most popular area for newcomers to Quebec. And most of these people come from French-speaking West Africa. Is this a possible solution for Quebec to increase the number of immigrants, of economic class immigrants from Francophone countries in Africa who could come to Quebec to rebuild their lives? Thank you, Madam Chair, and I thank the member for his question. I think it won't be long before Quebec's political weight or demographic weight will be twice that of Quebec. If we look at the Canada of tomorrow, there's a demographic change that's going to take place. Immigration is only one factor among others, but it is a significant one. And when we discuss the future of the Federation, we have to see in a far broader way. Over the decades, Quebec and Ontario have signed agreements to provide more autonomy, or rather Ottawa and Quebec have signed agreements on giving Quebec greater authority over immigration, having a greater say in immigration. But we see that requests for study visas and others from students in Africa. I beg your pardon, Madam Chair. Sir, I asked about economic class immigrants. Has Professor, I wondered if Professor Taillon has anything to say about the economic class, because it is the vast majority. There are people who come here to study, but they're not admitted to Canada or to Quebec automatically to stay. So I think that there might be something that could make a big difference. Madam Chair, this is one of the many possible solutions, and I deplore the fact that in the processing of certain requests, those from people in West Africa, well, this is an issue. In 1867, Francophones in Quebec and in the rest of Canada had a certain demographic weight. This demographic weight has been declining. I don't know where the fault lies. Perhaps if Quebec had been an independent country, it would be different. We won't know. But we have to find solutions for it in terms of the electoral map with respect to the Senate, but also solutions about how Quebec, how Ottawa deals with immigrants who want to come to Quebec. There are people writing to me. They say their files have been postponed and sometimes outright rejected. Mr. Taillon, I'm now over my time, so if you can give me a very quick answer. I'd like to know, Madam Chair, I'd like to know if this could be done without an amendment to the Constitution. Well, it's simple. Bill C-14 already amends the Constitution. Section 2 of the bill, or Clause 2, says that the Constitution Act of 1867 has to be read and interpreted in a certain way, so it explicitly does change things. C-14 is already an amendment. The only difference is that through this procedure in C-14, there are things that a parliament has the right to do and others that it does not have the right to do. It needs the agreement of 7% of provinces and over 50% of the population. This would abolish the principle of proportional representation. And it would change it, certainly. It's already been changed for the territories. To do a bit more for other situations, that is my point of view. Thank you, Professor. I'd like to know, I think perhaps the same amount of time should be taken for questions as for answers, because we need answers to the questions that members here would like to ask. So, Mr. Terrien, you have the floor. Thank you, Madam Chair. First of all, I would like to commend our witness. I quite agree with him, papering over Quebec's demographic decline, that this will simply paper it over. Quebec is losing its political weight because of its demographic weight, and that's something we've known for a while. Now, on the one hand, we have this problem. On the other, we have some ideas for a solution. Parliament accepted the idea that Quebec was a nation with a common language, which is French. It is not a province like the others. It is a nation, the only province that is considered to be a nation. So it should have powers that are related to this recognition. There was another motion passed to a great majority, and that was what Quebec should not lose members, where Bill C-14 would consolidate its position, and also that Quebec shouldn't see its political weight in the House of Commons diminished, and C-14 does not accomplish this. Now, given that everyone seems to be in agreement with the fact that Quebec is a nation and should be able to preserve its political weight, I think it's high time that it be recognized in legislation. My colleague, I don't remember his writing. My colleague, the member for Paul Ilmer talks about immigration. Premier Legault asked for greater powers in immigration or asked for more help with immigration and was refused. I have a question, a very simple question, Mr. Taillon, and you may be able to enlighten us. What can Parliament do in order to guarantee, and I say guarantee, Quebec's political weight in federal institutions? Well, first, there are two things. First, there would be changes in rep by pop. There were changes made to rep by pop for the territories. So we could have the same thing, a statistically marginal change that would allow Quebec to maintain its political weight close to 25%. This would take political courage because, indeed, this could lead to great debates. Does it comply with rep by pop? But a parliament that had the will to do so could defend this as it did for the territories. There could be a change made while having rep by pop respected. There are other ways of maintaining Quebec's political weight in Parliament. Senators would have to be appointed based on the province's recommendations, and the same thing would have to be done for other appointments of federal jurisdiction, for example, Supreme Court justices. In order that federalism means something, it has this huge power to appoint people. The Prime Minister of Canada appoints all senators, but there is party discipline for all parties, but he appoints all ambassadors as well. I think there has to be an inversion of this concentration of power. Madam Chair, the Supreme Court recognized effective representation. It should be that electoral weight is not disproportionate. And the second aspect is that respect of natural communities, according to geographic and communitarian characteristics, should be considered. Madam Chair, here is where we brought in the Senate clause. In the Charlottetown Agreement, it was guaranteed that Quebec would not lose its historic political weight. That was in 1992. We know what happened with the Charlottetown Agreement, Charlottetown Accord. In your opinion, might it be a good idea, might it not be a good idea to look at Charlottetown and look at the Quebec Nation clause and see if we could guarantee a floor of 25% for Quebec's representation? Well, rep by pop is enshrined as a limit when it amends these issues, when the government amends these issues. Supreme Court decisions have sent very clear messages that this is not a strictly mathematical approach, that this is not the only concern. These issues are very sensitive because Canada has managed to avoid the American trap of having electoral maps decided by partisan concerns and interests, and it has tended to cultivate a certain leeway, a certain freedom to act. And it is around this idea that we talk about effective representation. Well, proportional representation for the Supreme Court is not an absolute. There is the will to move towards this objective, but we are a very complex federation, and in such a complex federation, other concerns have to be borne in mind. This said, there will always be greater leeway for statistical differences, for example, between urban and rural ridings in the same province, as there is leeway, in my opinion, for changes or differences between provinces and territories. But I think even if this leeway could be used, it has been used for other issues, and it could be for Quebec's political weight. So I just want to make clear the Quebec clause is something we could use, and this is what the Bloc wants. We want a bill that will respect this. Thank you very much. Thank you. Ms. Blaney, 6 minutes, please.
Chair, and as always, through you, I'll be happy to ask the professor some questions. I appreciated his presentation today. I think that, one of the things that I spend a lot of time considering and have heard from many Indigenous leaders across Canada is the fact that our democracy was very much built on and continues to be built on a colonial practice that often silences the voices of the first people of this land. And when we talk about fairness, when we talk about looking at democracy in a new way, I think it's very important that we never forget those voices and how they've been isolated. And I think of the many communities that I represent, and when there is an election within their own community, of course, we see between a 90 to 95% participation rate, meaning very much that Indigenous communities are very connected to a democratic system. What they're not connected to in the same way, I think, is the Canadian democratic system. And part of that is based in the lack of representation. So we know that the House of Commons largely runs on a representation by population basis. But there are exceptions, like the one that you spoke of earlier about provinces having no less House of Commons seats than Senate seats. And I'm just wondering, in that context, is it important for us to explore representation in a broader context, especially around the First Peoples of Canada? I know there's been a lot of discussion about how those voices can be amplified, and the system right now, of course, sort of leaves it up to parties to nominate people and bring forward those voices. But should there be seats in our Parliament and in our Senate that are set aside specifically for Indigenous communities and making sure that those voices are heard?
Merci, je remercie Madame la Présidente, la députée, pour cette question.
Madam Chair, I'd like to thank the member for her question. Now, what I had said initially had to do with the very delicate issue of Quebec's demographic weight, which has been declining steadily since 1967. But there's also Indigenous representation in the House of Commons, which is of utmost importance. And this confirms the problem that I've been underscoring, and that is that this country, this federation, cannot indefinitely forego certain debates. We can't put these debates off any longer. Now, to create a relationship on an equal-to-equal basis, this is something that cannot be done unless there are certain constitutional debates. And I think that one day we may have to, perhaps have a certain number, a certain space for Indigenous persons in the Senate, in the House of Commons. These are issues that have to be looked at. But if there are wins for some people, this should not be to the detriment of other people. This has to be looked at from a very broad perspective and other than the electoral map, because we have to have greater Indigenous representation in federal institutions and at the same time provincializing our Senate and making changes to seat distribution in the House of Commons. I think that the question of Indigenous representation could be added to our debate. Otherwise, we'll fall into an area of constitutional taboos where we can't deal with certain changes. We cannot indefinitely put these debates off.
Your comments on that, and you have talked several times about having this debate on the Constitution, which I think would be an interesting thing to move forward with. But I guess where I'm sort of curious is what other countries have had this kind of debate? Is there particular models that you think are more meaningful? I think as we talk about representation, that is something that is incredibly important. You know, there are a lot of identities in Canada. That's something that Canadians are proud of, but I don't think we always amplify the voices that we should. We look at our federal systems, we still see continuously that the people that are most prominent continue to be male and continue to be white and straight often. So if we're going to talk about how to represent identity, how to make sure those voices are heard in a more profound way, and you're talking specifically about a debate in this sort of constitutional realm, so can you tell us what would that format look like? Has other countries done it more effectively than others? And if you have any examples for us, and I think you will answer that and my time will be done.
Deux choses sur l'aspect droit comparatif.
Two things. In terms of comparative law, I don't have a perfect example at hand that might answer your question. But with respect to Indigenous issues, we might look at Australia and New Zealand, which are dealing with similar difficulties and similar challenges. But this, both Canada and these countries perhaps could look to each other for inspiration. Now, with respect to the debate, the constitutional debate, the text of C-14 already amounts to a constitutional debate. Its very wording says that from now on, the 1867 Constitution Act will have to be interpreted in a certain way. But this is complex. There are all kinds of rules such that only the Canadian government could amend it, or that it takes the agreement of 7 provinces representing 50% of the population. But given our history and our political difficulties, we have a tendency to sweep under the carpet any questions which might affect the federal government's unilateral power. But here with C-14, this might be something that we could use, but I think we're preventing ourselves from taking another path, perhaps a path, the path of the federal government acting alone. Thank you very much. We'll continue with our second round. First, Mr. Kmich, then Ms. Romado, then Mr. Terrien, and 2.5 minutes for Ms. Blaney. Now, we have other witnesses that are coming, so I'm going to have to cut you off if things go on for too long a time. So, thank you very much, Mr. Taillon. Thank you, Mr. Viss.
To recognize Quebec as a nation within a united Canada. And it got me thinking back to the days of Confederation in Political Science 101 when we learned about Cartier and Macdonald and the creation of Canada as we know it today. And in Western Canada, we were taught that Cartier and Macdonald had, under the BNA Act, had some economic interests in mind. And those economic interests were largely focused in 2 provinces, Quebec and Ontario. It was also interesting. I know when I remember looking back to the BNA Act, there was no reference to region as well in the original Constitution of Canada, which is still obviously in effect. In British Columbia, I appreciated your comments about possibly electing a senator. But frankly speaking, if Western Canada doesn't get some type of recognition moving forward, there is going to be major constitutional battles. So in one respect, I agree with you that we need to have those tough conversations, because one other thing that's referenced in the Constitution of 1982 is the rights of individuals. And I represent individuals who pay just as much tax as individuals in the province of Quebec to the federal government. But I have a hard time coming here and saying that your vote is worth less than a Quebecer. And it's not just me saying this. Donald Savoy, the Canada Research Chair, has spoken at length about the attempts of the Laurentian elite in Quebec and Ontario in the public service. This is Canada. This is serious stuff. Laurentian elite, about the concentration of power that was designed in our Constitution of 1867, still largely exists today in the formation of our public service. So what do you say to a Western Canadian who simply just wants an equal say in this federation? And secondly, if Quebec had underrepresentation like British Columbia, I think Quebecers would be up in arms. And BC and Albertans, they've been up in arms in the past. It happened in 1993. And it's not a far cry, even based on your analysis today, to see that happening again. It would maybe perhaps if we adopt this threshold that we're discussing today, recognizing the 43rd Parliament as the new standard bearer for representation in the House of Commons, but did something afterwards to improve the allocation of seats in Western Canada. Do you think that's something many people in Quebec would accept? Through you, Madam Chair.
Soyons factuels, il n'existe pas.
Well, here's a fact. There is no underrepresentation for the Western provinces or Quebec in the House of Commons, since representation by population exists. But in the Senate, it's not the case. In the House of Commons, the principle of rep by pop is a compromise, an historical one, since under the Act of Union, and they did this in order to assimilate French Canadians, Lord Durham talked about equal representation, which allowed for the underrepresentation, rather, of French Canada and Canada from 1840 to 1860. There was extraordinary underrepresentation of French Canadians. So in 1867, you had a pact of nation to nation, and they decided on rep by pop, which amounted to a kind of justice in the distribution of seats. Now, the Quebec never anticipated that its weight in Confederation would be affected by various pieces of legislation that would diminish Quebec's demographic weight. Now, there was a four-part partnership created in 1867, and a result of this is that Quebec is declining. It's demographically declining within Canada. Now, how can we deal with this?
That Quebec never anticipated the population distribution that we have today. And I think that's the constitutional void that we find ourselves in. And in the context of changing the threshold to protect seats in Quebec, it's a problem unless we do what you actually talked about, another constitutional reference or another constitutional discussion with the provinces. The problem we're addressing today, the Band-Aid that we're doing, and it's not just Liberal governments that are guilty of this, it's Conservative governments too. The Band-Aid that we're applying today is only going to have to be ripped off in 10 more years, and we're going to be having the exact same discussion until we reach some sort of new and agreed upon equity between the provinces, especially, I might add, those that pay equalization. We're going to be basically waiting for another Reform Party or another Bloc Québécois party, maybe a second separatist party in the House of Commons to erupt and fight for their perceived regional rights. Thank you, Madam Chair.
Thank you. Mr. Taillon, voulez-vous 15 secondes?
Mr. Taillon, would you like to take 15 seconds to comment? Well, I don't want to take any more time than that which I am allowed. Thank you. Ms. Romanado, you have 3 minutes. Thank you very much, and I'd like to thank Professor Taillon. I'd like to thank you for your testimony. At the present time, Quebec's population, and I am a Quebec Member of Parliament, we have over 22% of the population of Canada. Given you're saying we should raise that to 25% of the political weight, or 25% of seats in the House of Commons, it would take the agreement of 7 provinces and territories. Do you think that it will be possible between now and the end of June next year to hold this conversation with the provinces and territories in order to increase the representation of Quebec to 25%? At the present time, C14 can guarantee that Quebec and the other provinces will not lose seats. But according to your recommendation and the recommendation of the Bloc Québécois, we would have to reopen the Constitution. Do you have any comments? Well, on the one hand, abrogating the principle of representation by population, well, we know that that would require the 7 provinces 50% of the population. But it would only take certain small exceptions, certain small changes to this principle of rep by pop. This could be allowed. This has been confirmed in the case law. And it could be done by federal power. They could unilaterally change the text. This is where I say there is some leeway, there is some room to act. Now, it's what the Bloc Québécois is proposing with its 25% threshold. Would that do it? Well, given the what C14 proposes, is there another threshold that might be established? Maybe. But rep by pop is a constitutional principle, among others, that could allow for certain changes. We've seen this in case law. We've seen it in Supreme Court decisions. And the Supreme Court has recognized that the complexity of the Canadian Federation allows us to use this leeway. And I have agreed to that. Thank you very much. Thank you, Mr. Terrier. Ms. Blaney is sharing her time with you, so you have 4 minutes. Thank you. I think that we have to listen to history. We heard the same things during the Meech-Lake Accord discussions. They talked about distinct society. English Canada wanted the distinct society to be a concept with no power. And Quebec was stupid enough to say, okay, and we were had. Sorry, Mr. Terrier. I'm not the one who said that. I wasn't the one who said that. But I think that we should continue with, it should be the witness who speaks. Well, here we are with the concept of nation. Jacques Parizeau talked about a trinket. We voted for this in the House, and it was accepted by a great majority. But it's only meant to be a little trinket, to please Quebecers. But we're saying, look, you said that Quebec was a nation. There are actions that have to be taken in order to show that you respect the fact that Quebec is a nation. When my colleague said, well, I can't understand why Quebecers have more power and we're all paying taxes. Does he not realize that Prince Edward Island has 4 times more representatives than others? Listen, this doesn't work. We have seen on many occasions that we are being made a minority, and we want to stop our being made a minority. And this would enshrine our declining minority status. I want to know what the professor thinks about Quebec's becoming an even smaller minority within Canada. I'd like to know what our witness thinks. Well, that's a complex issue. Well, since the 1890s to the 1960s, there was a deliberate policy to contain French-speaking Canadians, especially outside Quebec. And this very dark period of our history had demographic repercussions, which are still being felt today. And there have been provinces since 1867 which have not been kept. Quebec was happy to agree to representation by population. We found it just because we had been the victims of injustice not having had this in the past. There was the idea that this spirit of seeing Quebec properly protected, it hasn't really happened or been respected. Now they're trying to inject more. I think if we could inject more provincial influence and power in this discussion, I think that there are things that could be done through the Senate, and these are solutions which could allow us to have, or could allow the provinces to have a greater voice. There is far too much power concentrated in the Prime Minister's office. Well, I think if there were senators that they could choose, perhaps who would chosen by Quebec and then appointed by the Prime Minister, well, I think that this would be a win-win situation. In the House of Commons, this compromise of 1867 cannot be a mere mathematical calculation, which is only there to confirm Quebec's decline. There is this space, this room to move that we can use. Now, with what is done in C14, yes, it may stop its representational decline, but only by a fraction of a percentage point. We have a parliament which, if it wanted to go further, it could go further. And it might try to deal head-on with the issue of how to avoid the decline of Quebec's political weight, of Francophones' political weight overall in the country, and of Quebec's political weight, which is the only truly Francophone province and the only one with a civil law tradition. Now, how could this federation deal with this unique province? Thank you, Mr. Terrien. And thank you, Mr. Taillon. We appreciate your comments very much. We appreciate the time you've taken for the committee. And if you have any other comments you'd like to share with us, could you please get them to the clerk? And he will make them available to committee members. So have a wonderful day and stay safe. Mr. Fergus. Yes. Mr. Fergus, yes, Madam Chair. Point of order. I have a great deal of esteem and respect for Mr. Terrien and Mr. Weiss, but there is a standing order that states that we have to use appropriate language, things that will not be inflammatory. I think that under your chairmanship, Madam Chair, we have a committee that is very fraternal, collegial, and I think it's important that our language should be perhaps a little gentler. Thank you for your comments.
For our next panel, we will return in 2 minutes. Thank you.
So we'll now begin the second part of our meeting. We have the Minister of Intergovernmental Affairs, Infrastructure and Communities.
Blanc, accompanied by PCO officials, Mr. Alan Sutherland, as well as Ms. Rachel Pereira. Mr. Blanc, we give you up to 5 minutes for your opening comments. Welcome to PROC Committee.
Madam Chair, thank you. I'm happy to be here. Good afternoon, colleagues. As you said, Madam Chair, je suis évidemment très heureux
d'être devant vous pour discuter le projet de loi C14, connu sous le nom.
I am very pleased to appear to speak to Bill C14. Madam Chair, you did mention the presence of my colleagues of the Privy Council.
is underway currently on the basis of the Chief Electoral Officer's calculations. On October 15th, 2021, the Chief Electoral Officer announced the new distribution of seats in the House of Commons allocated to provinces and territories based on the constitutional formula and population changes over the last 10 years. The new distribution, as proposed by the Chief Electoral Officer, would see the House increase by 4 seats, from 338 to 342, with 1 additional seat for British Columbia, 3 additional seats in Alberta, 1 additional seat in Ontario, and 1 seat being lost in the province of Quebec. La perte d'un siège à la Chambre des communes est
Importante et nous comprenons les inquiétudes des citoyens du Québec. C'était une position articulée par mes collègues au caucus libéral du Québec et par d'autres collègues à la Chambre des communes également. C'est pourquoi préserver les sièges au Québec à la
Monsieur
Chambre
Blanc,
des
si on
communes.
peut.
This is why is it starting? Is the interpretation working? We'll continue, please. Thank you, Madam Chair. In order to maintain Quebec's number of seats in the House of Commons, well, this is a priority for our government, and C14 is the government's response to this priority.
Section 51 of the Constitution Act 1867 to ensure that no province will have fewer seats than it did in the 43rd Parliament, the last Parliament. Simply put, it will replace the 1985 grandfather clause, which came in 1985 in Mr. Mulroney's first term in Parliament, with a 2021 equivalent. This means Quebec will not lose a seat in this redistribution process. This bill, Madam Chair, is not just about Quebec. The 2021 grandfather amendment being proposed would apply obviously to all provinces, raising their minimum number of seats and protecting them in the event of a shift in population in the years to come. Colleagues, this is a small, but we think impactful amendment. It will preserve Quebec's 78 seats in the House of Commons while respecting incremental gains in the provinces of British Columbia, Alberta, and Ontario. Furthermore, I would point out that Bill C14, the seat allocation formula, the way in which seats are calculated remains exactly the same with all existing protections. For example, the senatorial clause, the representation rule, and the territorial clause obviously remain firmly in place. 10 commissions de délimitation des circonscriptions.
10 electoral boundaries commissions, nonpartisan commissions, said September 1st, that were established September 1st, 1 per province, is a fundamental component of our process of deciding electoral boundaries. And I'd like to take this opportunity to thank the members of the various commissions and boards for their work countrywide.
Their work following the release of the final census data in early February of this year. As they prepare their electoral boundary proposals, they will hold public consultations before submitting reports to Parliament for consideration and will ultimately decide on the changes to be made within each province. In order to ensure that C14's new grandfather clause applies to the current redistribution process, the bill includes a number of transitional provisions to ensure what we hope would be smooth implementation. and I've obviously had a conversation with the Chief Electoral Officer, M. Perrault, in this regard. For example, upon coming into force, Bill C-14 would require the Chief Electoral Officer to recalculate the number of seats in the House of Commons with the updated 2021 floor. This means Quebec Electoral Boundaries Commission would prepare a boundary proposal that takes into account the new seat allocation, in other words, 78 seats. However, they will have the same 10-month time frame as other commissions to complete their work in the ongoing redistribution process as required by legislation. The transitional provisions additionally ensure that the work of other provincial boundary commissions can continue to advance uninterrupted. This approach will ensure, should Quebec's Electoral Boundaries Commission require more time to complete their work as a result of this recalculation, they will not delay the implementation of the work completed by other provincial commissions. Finally, Madam Chair, I think it's important that colleagues are considering this legislation. I thank you and the members of your committee for the work you're doing. Our government is obviously committed to working with all parties and all members of the House on this important issue, and I look forward to our conversation in the 50 minutes that remain. Merci beaucoup, Madame la Présidente.
Thank you, Madam Chair.
Appreciate you being here with us to discuss this important legislation. We too look forward to the exchange. We will have our first round, 6 minutes, will go to Mr. Comich, followed by Mrs. Romanado, and then Mr. Terrien, and then Ms. Blaney. And I would just ask that all comments be made through the chair. Mr. Comich, 6 minutes to you.
Thank you, Madam Chair. So my first question to the Minister is, during the second reading debate on the bill, he said, we studied all possible options. I wonder if the Minister could explain what those options were that the government considered.
Madam Chair, through you to Mr. Comich, thank you for the question, and thank you for your thoughtful presentation as well, Mr. Comich, at second reading of the legislation. Obviously, I'm not going to discuss what options that I laid out before Cabinet. That would be inappropriate. But it shouldn't surprise colleagues that we were looking for a way to ensure that the representation in the province of Quebec did not diminish. We were conscious of the need not to proceed in a way that would trigger potentially a constitutional amending formula, the 7 provinces out of 10 representing 50% of the population, the standard amending formula. Some options suggested in the view of legal advisors would have triggered that formula. So we thought this was, in fact, the only surgical, simple way to preserve the number of seats in the House of Commons at the last Parliament.
So, Minister, the Minister Chair called the legislation minimalist. So that's, I think, a point of agreement that we have. And I generally like minimalist legislation that does the least damage possible to our constitutional structures. During that second reading debate, the Minister also referred to a principle of modified proportional or proportionate representation. I wonder if you could explain what that principle means to the Government of Canada as it was applied to the legislation and any future redistribution legislation it might consider.
Madam Chair, thank you. Obviously, we're considering no further redistribution legislation at this time. We think it's important that commissions be allowed to, as best as possible, complete their work in the timelines prescribed by legislation. The modified proportionate representation, for example, the riding of Labrador, because of its geography, necessarily has fewer electors than might a riding in St. John's in the province of Newfoundland and Labrador. There's obviously the territorial examples, which are long-standing. I think of my own province of New Brunswick, which, because of the application of the senatorial clause, has to have 10 members of parliament. If you divided the population of New Brunswick to try and get to the electoral quotient, the national number, it might be less than 10 MPs. But there's an example where my province will always have 10 members of parliament, or the province of Prince Edward Island will have 4, and a strict representation by population national formula might lead to a different outcome.
I have some questions, Madam Chair. Now, on the transitional provisions, it is possible that under this legislation there might be 2 different representation representations for the next general election, depending on how quickly the Quebec Boundaries Commission were to be able to write up a new set of maps, depending if this legislation passes. I'm wondering if either the PCO officials or the minister, if there's an example in the past of where this has happened, that a federal election were held in Canada with two different representation orders affecting different provinces, and then if they could also maybe speak to the potential costs associated with this legislation and one Boundaries Commission having to redo some of its work.
Well, Madam Chair, through you, Mr. Kimmich, thank you for that question. I think it strikes at the heart of what is an understandable concern for those that want this to be an appropriate, orderly process. If Parliament, in its wisdom, decides to maintain, for example, 78 seats in the province of Quebec, the Quebec Electoral Boundaries Commission will obviously respect that decision, that legislative decision of Parliament. Should there be a transitional period where an election were to happen before the Quebec Electoral Boundaries Commission would have completed its work, as Mr. Sutherland just indicated to me, Quebec seats would remain at 78. That is not an ideal situation. That's why I'm hoping that colleagues in this House and in the other place, if there is a consensus to support this legislation, can do so in a way that we don't unduly create uncertainty for the Commission. These are people that are going to be working extraordinarily hard and are doing serious work, and obviously the uncertainty that they might face is not ideal. And I worry about that, but I don't know, Mr. Kimmich, if perhaps Mr. Sutherland or Ms. Pereira can provide examples if there have been other circumstances where you would have had sort of a hybrid, if you wish, series of maps. I don't know the answer to that, but maybe Mr. Sutherland or Mr. Pereira does. And we'd be happy, obviously, to reply in writing through the chair if there's more detail you'd like. Go, Al?
Yeah, Madam Chair, just to respond to the question about, has there ever been a situation where you had two rules existing simultaneously? Not to my knowledge. If there is additional information, we would, of course, be pleased to get it for you.
Madam Chair, how much time do I have left?
40 seconds.
It's pardon, you said 40 seconds, 40 seconds?
Yes.
Okay. So to the minister, through you, Madam Chair, why they use the 43rd Parliament as the new setting point of the grandfathering clause instead of using a date like it used to be 1985, or why isn't it being set at after this legislation passes? So, for example, setting it at whatever it is at the end of the 44th Parliament. In this redistribution, Alberta is to get 37 seats, and that would form its new floor for the minimum amount of seats that my home province would have in Confederation. So I'm just wondering why the 43rd Parliament? Why didn't they pick a date or a different Parliament at which to set it at?
Mr. Kimmich, that's a very good question. I don't think, out of respect for colleagues, I want to make up an answer. I'd be happy, again, to look at previous precedents. Mr. Sutherland did tell me that in the past, to your previous question, in the past we have done, apparently previous parliaments have done this in the context of a majority government, so there may have been more certainty in terms of the dates certain for the Electoral Boundaries Commission, just to add that. But Al, when we were presented with options by the Privy Council office, this was thought to be the right way to grandfather the seats that existed, including 78 for the province of Quebec. But we can perhaps provide more information if there were other precedents. I actually don't know that, Mr. Kimmich.
Thank you, Minister LeBlanc. Ms. Pereira, do you have an answer?
I would just say it also provides a measure of clarity in terms of the number of seats that we are seeking, to reference the 43rd Parliament, in part because the CEO, the Chief Electoral Officer's calculation was announced in October of 2021. So if we were to refer to 2021, that could raise some confusion as to which number of seats we're talking about. So referring to the 43rd Parliament provides that clarity in the Act.
I think that's an excellent answer. I thank you for that. Ms. Romanetto, up to 6 minutes for you.
Thank you very much, Madam Chair, and through you, I'd like to thank the Minister and departmental officials for being here today. It's tough because Mr. Kimmich actually asked a few of the questions that I was hoping to ask. One of the questions, as a member of Parliament from Quebec, it was very important for me that Quebec not lose a seat, and so I know that when we had conversations in Quebec caucus, it was just not optional that Quebec would lose a seat. In terms of representation. So in terms of C14, it looks like we are doing what we've done in the past. So in the 33rd Parliament and in 2011, we made that little tweak, the adjustment, the small amendment to make sure that seats were not lost. Now, in the previous panel, one of my colleagues mentioned, okay, this is kind of like a Band-Aid solution, right? So we have to fix this, but and every few years we have to keep going through this situation where we're looking at the census data, we're looking at where we are, and we keep making the small amendments. So I'm going to ask a question that probably my colleagues are not hoping I'll ask, but is it time that we also start looking at, like, for instance, the Bloc has proposed that we increase Quebec's representation or guarantee it at 25%, which I believe will require a constitutional amending formula. Do we need to look at opening up to the Constitution to start thinking about different ways that we are preparing the representation across Canada, whether it be the seats in the House of Commons or in the Senate? If you could elaborate a little bit. Thank you.
Madam Chair, Ms. Romanato, thank you for the question, and you're right. You were one of my colleagues in caucus and in conversations we had that recognized the importance of Quebec maintaining, not losing a seat, maintaining its 78 seats. So as a member of Parliament from Quebec, I thought that voice was important and certainly was important as we drafted this legislation. I thought I didn't know you were going to ask questions about constitutional amendments. I thought you were going to ask about some effort in a previous Parliament to change the electoral system. I seem to remember after 2015 we had a happy outing in that regard. So that certainly doesn't feel like it's on the agenda either. And to be blunt with you, Ms. Romanato, neither would be opening the Constitution. Successive governments, including Mr. Harper's, Mr. Chrétien's government, opening the Constitution for something like changing the representational formula that exists now, or changing Senate seat allocations, is certainly not a priority for this government. And I'm partial to the school that says even if we had consensus on, for example, an issue as seemingly surgical as that, when one gathers first ministers at a constitutional conference table, they arrive with their own lists, and the lists are long, and the results are complicated, and it sucks a great deal of energy away from issues that we think are important to Canadians and that we should work on with our partners in the Federation in a very collaborative way. So we're focused on working with provincial and territorial governments in a way that doesn't require constitutional amendments, but that better serves Canadians, and that's the work that I'm happy to try and do every day for our government.
Excellent questions. I thank you. Mr. Terrien, jusqu'à 6 minutes pour.
Mr. Terrien, up to 6 minutes. Thank you, Madam Chair. I'd like to welcome the Minister and his team. And I will put my question through you, Madam Chair. Quebec is a nation. There was a vote in the House of Commons, and the House of Commons passed it. Now, the Minister will correct me if I'm wrong, but I believe the Minister voted for the fact that Quebec is a question. Does he consider that Quebec is a nation? Yes, Madam Chair, I do accept that Quebec is a nation within a united Canada. That wasn't in the motion. Now, the fact that the vote took place is, well, I was in a restaurant in Montreal for a meeting, so I did not vote that evening. Mr. Harper was Prime Minister. I don't remember the date, but that evening I wasn't there. But I believe that Quebec's a nation just as the Acadian nation is one. Now, when the House of Commons votes for a motion like this, they talk about we're talking about the 2006 motion, but you say in a united Canada, but it wasn't in the motion. Now, the fact that Quebec is a nation, could this have an influence on powers in Quebec, powers that are not a mere trinket? Thank you, Madam Chair. This is a totally appropriate conversation. I think we can talk about what it means in legal terms, in terms of public policy. There are all kinds of examples where the federal government will support minority language communities. And there is the fact that the House of Commons has said that Quebec is a nation, but this does not change the Canadian Constitution. This is another subject of discussion. I would accept that in terms of how our government applies public policy, this is something we have to bear in mind, to remember that Quebec is a nation. But we did consider it a good idea this is why we want to freeze Quebec's representation, to maintain it. Minister, you're an experienced politician now. I understand why you're trying to sort of take away from my question time. You say, well, there's a Quebec nation, but not more power. But on March 2nd, you voted for something that said, and you know what I'm going to talk about, one, that Quebec would not lose seats in the House. So that is a victory. Okay. Second thing, for Quebec not to lose political weight. And in this iteration of C14, Quebec keeps 78 seats. But instead of 78 seats out of 238 seats, it will be out of 342 seats. So I think we could say that if things continue this way, Quebec will lose political weight. This was adopted with an overwhelming majority. I see Mr. Turnbull is in agreement, and those of you who voted for it, I think, well, yes, you voted for it. But why not follow up and go further? Well, thank you, Madam Chair. I'd like to thank Mr. Terrien, who is an experienced politician with sound judgment. I admire what he's trying to do. I was so bad in math and science that I studied law, and I didn't even study tax law. But Mr. Terrien is correct. We studied the motion and wanted to make it such that Quebec would not move from 78 to 77 seats. So we felt we were protecting Quebec's political weight. And let's be clear, Madam Chair, we have not initiated a constitutional discussion, and we're not trying to see whether something passed by the House of Commons would change the Constitution. So we're saying 78 seats out of 338 rather than 342. Well, that's a loss of political weight. We do know that the Fair Representation Act, we know that we don't have to change the Constitution. Section 44 of the Constitution Act, and Mr. Taillon, the constitutional lawyer, said you only have to make small changes, perhaps under the Quebec clause, and have a floor of 25% for Quebec. So I'll put my question again, knowing that we don't have to reopen the Constitution, and that argument is not one that holds water. What do you think we might do? Well, Madam Chair, we may have been inspired by what Benoit Pelletier, a constitutional lawyer at the University of Montreal, he said, and the quote is in English:
Quebec a specific share of seats in the House of Commons, regardless of its share of the population, would clearly go beyond what Parliament can do on its own. That is a 750 amendment de la Constitution. Et il y avait beaucoup d'autres experts qui nous ont avancé cette idée-là. Alors,
and there were other experts who expanded on this idea. And Mr. Terrien, while I may not agree with him that we have that much leeway in C14, but there may be different opinions, and I recognize that fact. Well, the senatorial clause, we never needed that. But there's what Mr. Pelletier said, but the difference between Mr. Pelletier and Mr. Taillon is that we were able to put questions to Mr. Taillon. What I'm hearing here, I would have liked to ask Mr. Pelletier questions about that. I do not agree because history shows that 4 times representation has been changed, and we don't have to reopen the Constitution. We didn't have to then. Why would we now? Well, we could spend our time quoting experts. There's Mr. McFarland, who is a professor of political science at the University of Waterloo. He is an expert in constitutional law. And he said the same thing as Mr. Pelletier. So the question before us is we don't want to diminish Quebec's political weight, but we want to guarantee a fixed, if we wanted to have a set percentage, well, we would have to deal with this otherwhere. Look at Nova Scotia compared to provinces that have increasing populations like Alberta. Now, there is a senatorial clause, and we know that this is a surgical means of changing some things. Thank you very much. Ms. Blaney, 6 minutes, please.
Chair, it's a very interesting conversation today, and I thank the witnesses for being here with us today. The bill is important in terms of ensuring Quebec and other provinces don't lose representation in the House of Commons, given the reality that Quebec's unique history, culture, language, and role in Confederation. Is the government contemplating changes that would also protect Quebec's share of seats in the House of Commons?
Madam Chair, through you, Ms. Blaney, thank you for the question. No, we're not contemplating other changes other than what's proposed in Bill C-14 to maintain Quebec's 78 seats, as was the case in the previous Parliament. We have no plans to go further in terms of the representation and in different provinces, but we're also conscious, as I said in my opening comments, of the work that the commissions are doing and the importance of allowing the commissions to have as much certainty as possible in terms of what number of seats they'll be dividing up per province. So we're conscious that doing that at this particular moment doesn't allow them to fulfill their legislative responsibilities in a way that we think would be respectful.
Thank you for that, Madam Chair, through you. The next question that I have is around the reality that the format that we're talking about is very colonial, and that we have a long-standing history here in Canada of colonialism and extinguishing often the voices of Indigenous communities. We know that some other countries have explored expanding their processes, their electoral processes, to make sure that the voices of Indigenous communities are heard. We also know statistically, if you look at elections that happen within communities, Indigenous communities, the voter turnout is extremely high, but we don't see that reflected, of course, in the other elections that happen in our country. So I'm just wondering, is there any discussion at this point about how we can amplify the voices of Indigenous communities, if there is any sort of goal towards having representation in both places in this Parliament to amplify those voices and make sure that those voices are represented? I look at New Zealand for a specific example. We know that that's incredibly important, and if we're going to talk about reconciliation in a meaningful way, it has to happen in all levels. And of course, having those voices represented here, the first voices of this country, would, I think, make a more wholesome and collaborative process. So I'm just wondering, is there any work being done on that and exploring that and looking at systems that are working in other countries and how they may work in Canada?
Madam Chair, Ms. Blaney, I think correctly identifies a challenge that all of us need to reflect on. She mentioned both places, the House of Commons, obviously, and our friends in the other chamber in the Senate. We have tried through the Senate appointment process to appoint a number of Indigenous persons to the Senate. I think they have, talking to my colleagues in the Senate, they have contributed enormously to the conversations and to the work of that legislative chamber, but we can always do more. Ms. Blaney correctly identified other jurisdictions. New Zealand, you're absolutely right, is in many ways a leader in this domain. Some provinces have in Canada, and I'm going by memory, some provinces have, in the case of Indigenous persons or even other minority groups, I'm thinking of the Francophone communities in Nova Scotia, have decided deliberately in their legislature to ensure that the electoral map reflects a way that those voices, as Ms. Blaney properly said, that are often not adequately heard or are not easily heard in a typical electoral redistribution cycle. So we have no plans, no legislation in that regard at the moment. But I take note that the Chief Electoral Officer, I was in the Cabinet meeting this morning, but released a report or his recommendations on a number of elements of the two previous general elections. And obviously, Madam Chair, if this committee or other committees of the House had ideas or wanted to pursue that, then we would be interested in those conversations. But I don't want to pretend that we have legislation pending or cabinet decisions around anything in that regard at this moment. As I say, we're conscious that we're at the front end of an electoral boundaries redistribution process. So we want to, out of respect for the legislated timelines in that process, not widen the conversation to a point where the electoral boundaries commissions won't be able to do their work, but perhaps following that process, if colleagues wanted to bring those kind of issues before, we would be more than happy to work with colleagues, because we do recognize exactly the challenge that Ms. Blaney properly pointed out.
That is all my questions today. Thank you, Madam Chair.
Thank you, Mrs. Blaney. We will now proceed with 5 minutes to Mr. Viss, followed by 5 minutes to Mr. Turnbull. Puis 2 minutes et demie to...
Then 2.5 minutes for Mr. Terrien and 2.5 minutes for Ms. Blaney.
Through you to Mr. Sutherland. The former clerk at the table of the House of Commons, David Gausseau, submitted testimony to this committee, and he talked about the challenge of dealing with increased disproportionality. And he writes, the current bill will increase that disproportionality from 44 to 46 seats from 3 of the provinces. For proportionality, Alberta should have 8 more seats. British Columbia should have 10 more seats. And Ontario should have 28 more seats for a total of 46 seats. Based on the commentary I've already heard from the minister, I acknowledge the challenging position any government is in dealing with changes to the representation in the House of Commons and avoiding a constitutional amendment. What type of advice did the Privy Council Office provide the government in respect to the structural underrepresentation of the 3 provinces referenced?
Madam Chair, thank the honourable member for his question. I think, and you've seen this in the earlier commentary by Professor Taillon, there is in the development of this legislation an attempt to balance and reconcile different aspects of our federation. The first is the issue of, sometimes it's called representation by population, sometimes it's called proportionate representation. That is clearly a defining feature of the legislation. But the other feature of the legislation is to provide protections to small and slower growing provinces to make sure that they get adequate representation. So when we developed the advice for the minister, we considered options that attempted to balance those 2 things. I believe that what you're referring to, and I only looked at it briefly, so the honourable member will forgive me if I've got it slightly wrong, but I think he was providing an illustrative example of if those provinces had the same representation as Quebec, that would be the number of seats that they would have. Yeah.
Madam Chair, all of the other committee members answered or posed my questions to this great panel. So if you will indulge me, Madam Chair, I will, because we do have a minister before us, I will kindly thank the minister for approving the Dominic LeBlanc Center for Aquatic Excellence in the District of Kent. And I would like to ask the minister if we could probably have a quick comment on the challenges that small communities like the District of Kent are facing in respect to inflation. And then this is a good faith question through you, Madam Chair.
Madam Chair, thank you, Mr. Viss, for the question. Naming an aquatic center after me seems a bit counterintuitive. I don't look like somebody who spent a lot of time swimming laps in a pool. So I'm flattered by your enthusiasm. And you're absolutely right. I represent a small series of small rural communities in New Brunswick. And it is a challenge, and we've talked about this with respect to projects in your riding, Mr. Viss, and on the infrastructure space. It is a challenge to have smaller communities develop or have the capacity to apply to federal programs, in many cases that are very technical and complicated. A net zero attestation clause ensures that many small communities, at least in the initial rounds, weren't able to benefit from these programs. I'm happy ones that are important to you did, but I think we have a lot of work to do as a government to ensure that the infrastructure investments are shared with communities big and small across the country. And I had this conversation at the Canadian Federation of Municipalities meeting in Regina with a series of small rural mayors last week on Friday.
Well, thank you, Minister, through you, Madam Chair. Just following up on MP Romanato's point, do you foresee in 10 years Parliament of Canada going through the exact same exercise that we're going through today?
If the current law obviously is maintained, there will be a redistribution process after every decennial census, so in 10 years, yes. I'm going by memory, but I was surprised if you take the projected population increases in the current, if you look at the last 10 years and sort of project the same population movements over the next 10, I would have instinctively thought that the number of seats in the House of Commons 10 years from now would dramatically increase. And it was a surprisingly small number, assuming, as I say, that some future parliament doesn't, in its wisdom, change those formulas. But this is a conversation that Parliament will have every 10 years, and we think that's a proper thing to reflect the movements of populations across the country. It was 6 seats. The projections would say, Madam Chair, the projections would say that, again, if the current, comme on dit en français, si la tendance se maintient, Bernard...
As we say, if the trend continues,
we would expect it to be 6 more seats in 10 years from now, but of course that will depend on a whole series of demographic factors.
Thank you, Minister. I know we're not here to talk about infrastructure, but when you do make that announcement in Kent, we welcome one in Waterloo as well. I do not need a response at this time, but you should definitely ponder it. Mr. Turnbull, 5 minutes to you.
Madam Chair, and I echo your sentiments with regards to my riding of Whitby. We look forward to projects being approved in Whitby as well. But back to the matter at hand, Minister, I want to thank you and members of the Privy Council for being here today to testify. It's an important conversation. It's clear to me that at this moment in time, Quebec is certainly going to benefit from these changes and by not losing a seat. But what was revealing to me about some of your opening remarks was that the surgical, I think you used the word surgical, changes that are being proposed in C14 are actually going to benefit all other provinces and territories as well. Would you say, is there any downside for the other provinces and territories as you see it, Minister, through you, Madam Chair?
Madam Chair, obviously I look forward to announcing a number of the important infrastructure investments both in Waterloo but in Whitby as well. And Mr. Turnbull and I have talked about some priority projects in his riding, and I look forward to hopefully being there this summer with him to announce them. But Madam Chair, Mr. Turnbull properly identifies the fact that under this current legislative proposal, Bill C-14, British Columbia would increase by 1 seat, 3 in the province of Alberta and 1 in his province of Ontario. That is by operation of the formula that the Chief Electoral Officer has applied following the last decennial census. So we take the position that this was a corrective measure to preserve Quebec's 78 seats, but in no way did we want to, as I think you were referring, Mr. Turnbull, take away from the importance of recognizing growing populations in those 3 provinces I mentioned. You could make the argument that adding 1 more seat to what had been the formula in Quebec dilutes the seats in those provinces. We don't think that that's significant. If you look at a total of 342 seats, 1 seat in 1 particular province, I don't think represents a dramatic diminution in respect to these growing populations in those provinces I mentioned, including your own, Mr. Turnbull.
Thank you, Madam Chair, to the Minister for that response. I wanted to quote Emmett McFarlane again. I know our chair will be happy. Associate Professor of Political Science at University of Waterloo, who's a constitutional law expert. He said, and I quote, "The seat allocation formula can be adjusted unilaterally by Parliament, but it has to stay within a reasonable margin for ensuring proportionality." So I'm wondering, through you, Madam Chair, to the Minister, whether C-14, in fact, as you described it, being minimalist and surgical, is within that reasonable margin.
Madam Chair, we believe it absolutely is. And the legal advice that we have indicates that it is entirely within Parliament's purview to make this sort of reasonable, modest adjustment that previous parliaments have made. And Professor McFarlane, amongst others, I think in their wisdom and based on their experience have confirmed that. And a scholar from the University of Waterloo, Madam Chair, is obviously somebody we'd want to listen to. He's not, for example, from the University of New Brunswick. I'll concede that. But in spite of that, I think his opinion carries considerable weight.
Madam Chair, through you, I wanted to refer now to the Private Members Bill C-246 and also quote Emmett McFarlane again. So I quote, "Once you start violating representation by population and you actually are enacting policy or constitutional change to protect one province over the interest of others," and this is Mr. McFarlane's words, "I think that's when constitutional amendment becomes required, and it would be more than just Parliament unilaterally doing it." End quote. So, I mean, I think what we've heard here is that by the census, Quebec currently represents 23 or just under 23% of Canada's population, yet what's being proposed in C-246 would guarantee Quebec no less than 25%, regardless of population decline. So would that require and trigger the amending formula? And I guess what I really want to ask is, what challenges do you foresee in holding up this process if that were the case? And doing this through a private members bill seems would like it could create quite a few challenges. Could you speak to that, Minister, through the chair?
Yeah, and the chair is indicating that I should be very brief. I will be. We do believe that legislated floor, I think it would take Quebec seats to 89 from 78, which Bill C-14, they would go to 89. We believe that would be ultra vires of Parliament, that would be outside the legislative scope of Parliament. It would probably trigger a series of legal challenges. It would, in our view, be counterproductive to allow the commissions to do the work they have to do. And as I say, we expect that the courts would, as Professor McFarlane and a number of others have indicated, the courts would conclude that is more properly a constitutional amending formula issue. And for the reasons, Madam Chair, that we discussed with Ms. Romanato, we don't think that is the most efficient and effective way to to resolve these issues in the very short term.
Thank you, Minister LeBlanc. Excellent vocabulary choice. Impressive. Mr. Terrien, 2 minutes et demie pour vous.
Merci, Madame la Présidente. J'aimerais...
Mr. Terrien, 2.5 minutes for you. Thank you, Madam Chair. I'd like to talk about some of the things, some of the projects in my riding. You know that, yeah, there's money coming for different projects. Yeah, okay, we'll talk about it. But I want to deal with this file. There was a constitutional lawyer who appeared before us. I think he was answering a question of Ms. Romanato's, and he said what we suggested, the 25% as suggested in the Charlottetown Accord, whether it was 25 or 24, we could discuss that. The problem is, we've talked to constitutionalists, and Mr. Turnbull mentioned this. I'd like to hear from these other constitutionalists. You know, the minister can't invite them, but Mr. Turnbull, he's very perspicacious when he speaks. And what he said earlier, he referred to this constitutional expert. I'd like to hear from this expert, because we've heard, okay, this kind of thing is possible, but I'd like to hear from an expert. Now, Madam Chair, through you, since 1987, the courts have recognized that there can be changes for effective representation, and that the House of Commons or Parliament can adopt measures to this effect. It recognized the principle of effective representation, which is guaranteed to electors. Two conditions are attached to this: the relative equality, so that the demographic or political weight would not be exaggerated. One vote shouldn't be more important than a vote somewhere else, but I know we're saying an elector is an elector, but it also proposes, and I'm reading this in the text, respect for natural communities with characteristics that are possibly geographic and of communities should be borne in mind. This is what's written, and this would make it as such, and this is the second thing I want to mention to the minister. The federal parliament has the potential to change the act, but strangely, bizarrely, what we're proposing as a percentage, 24, 25%, that wouldn't work. Why? Why would it not work? Because here it seems quite clear, but I'd like to hear the minister on this. Mr. Minister, you have 1 minute to answer the question without interruption. Thank you, Madam Chair, and I'm very happy to announce good news for people in La Prairie, a youth center in my friend's riding. We can talk about various shelters and other things. But these aren't the same thing, says Mr. Terrien. Madam Chair, Mr. Terrien is talking about very interesting constitutional discussions. There are the Supreme Court precedents, which he has cited. I'm not aware about the other precedent, the case he referred to, but these discussions about communities of interest, linguistic communities, and geographic communities are factors that will be considered in allocating the number of seats by the Chief Electoral Officer's formula as to the establishment of electoral boundaries. I can't really extrapolate and say that this would apply to a floor in terms of political weight. But we will be discussing these issues, as I said in my answer to Mr. Vice. Mr. Terrien, sorry. No. Thank you very much. Ms. Blaney, you have 2.5 minutes.
Parfait. Donc, on a...
Blaney, alors je peux pas prendre ces
Pas cette fois-ci. Donc, on a...
May I take her 2 minutes?
On m'a donné une question à Mr.
We have a bit of time left. There'll be a question for Mr. Viss and then Mr. Fergus.
Chair, just enjoyed this discussion so much today, and it got me thinking of one of my favorite New Brunswick scholars, Donald Savoy, the former Canada Research Chair, if not the current one in public administration. In his book, from a few years ago, Democracy in Canada, he referenced the Laurentian elite and talked about the concentration of in the public service of both Ontarians and Quebecers, and the public service culture and the culture in Ottawa, which isn't very representative of the culture of Western Canada. So this is something that I know the minister is somewhat aware of, but it is true in British Columbia, in certain parts, and much throughout Alberta, people do feel disconnected from our institutions here in Ottawa. My wife is from Ottawa, and she moved to British Columbia, and she said, when she first came there, she said, Brad, I had no idea about the wealth discrepancies that exist, or how far away, or that every neighborhood just doesn't have a nice ice rink like in the National Capital Commission that is funded by taxpayers. But my question is, what do you think maybe I'll ask this to our public servants, what do you think the public service of Canada can do to ensure better and adequate representation of Western Canadian values, and that might include value for taxpayer dollars? Thank you, Madam Chair.
Just remind us that we are here to talk about C14 with the side of infrastructure.
Well,
so
I'll just add to that this is completely related to C14, because what at the heart of C14 that we know as a fact is that British Columbia and Alberta especially, and Ontario, do not receive the representation, do not live up to the principle of representation by population. It matters to people. The election of members to this House of Commons has an impact on our institutions. Thank you, Madam Chair.
Chair, very briefly, I know we're running out of time, but Mr. Viss referenced Dr. Donald Savoy, who I'm very fortunate to count as a friend. He was a dear friend of my father's. He's somebody I see regularly in New Brunswick. And you're right, Mr. Viss, he's published, I think, north of 30 books. My favorite one is I'm from Bucktouche, which is a community in my riding where he grew up. And he has correctly identified a challenge. It's in the public service. I would argue it's in other national institutions to ensure that regions are properly represented. I worry about Francophone minorities outside Quebec. We worry, obviously, about Indigenous peoples. So across the country, the diversity of our country is often not reflected. The regional diversity, but other diversities as well are not properly reflected in institutions. The public service, you could argue, other national institutions. So it's a constant effort that our government is trying to undertake, and we would obviously welcome thoughtful suggestions. Like your wife, I grew up in Ottawa and moved to New Brunswick, so I went to another coast, but I totally understand that perspective that I thought Mr. Viss properly brought up at this table.
D'avoir cette chance. La tentation est grande.
Thank you, Madam Chair. There is a real temptation, an overwhelming temptation to talk about tramways in Gatineau. But, Madam Chair, I will restrict myself to talking about C14. But if the Minister has comments about the tramways, I would be very open to that. Any comments about the Gatineau tramways? Madam Chair, I'd like to talk about the electoral boundaries commissions. We heard about several options that are not in Bill C14. I'd like the Minister to talk a little more about what would happen if we don't support this bill. What would happen to the electoral boundaries system in Quebec, for example, if we weren't to accept this legislation, pass it at this stage? Thank you, Madam Chair, and I thank my colleague for his question. I understand Mr. Fergus, just how important the tramways project in Gatineau is for you. And I have discussed it with ministers from Quebec. I think we want to go forward with a study, and I was surprised at how much an environmental review, an environmental study will be, but I'm hopeful that we'll be able to talk about this with people in your riding shortly. Madam Chair, to conclude on the electoral boundaries commissions, as I said in my opening comments, we have an independent, nonpartisan body, and I would say respectfully to my colleagues that we have to be aware, as I say to Mr. Fergus, to underscore the very important work that these people accomplish. I discussed this with Mr. Perrault, the Chief Electoral Officer. I discussed it with him a few weeks ago. And this is why I hope that this committee, in its wisdom and with the help of members of the House of Commons, we will decide if it is the will of the House of Commons to pass Bill C-14. Seems that Mr. Kimich and other colleagues have talked about this. However, we have to be aware of the fact that, for example, in your province, Mr. Fergus, we can't take an unreasonable amount of time. That would not be ideal. To be in circumstances where we have two timelines. That would not be respectful to people who are sitting on the commission, and it would not lead to the results we hope for Quebecers for their new electoral map. Thank you, Mr. Minister. Thank you, Ms. Pereira, and thank you, Mr. Sutherland. The Thursday sitting of PROC is when we will deal with the clause-by-clause study of this bill. And then we want to get this bill back to the House, and I hope that everyone stays safe and healthy, that you stay safe and healthy. I just want to take a moment for Mr. Thériault. Madam Chair, given the minister's testimony, I would like to ask the committee that we invite one or the two constitutional experts who were mentioned by the minister, because this would help us to understand the minister's position on the bill and any amendments that might be proposed. One constitutionalist has appeared, and I think I'm a fair player. And I think that this or that constitutionalist, one or the other, might be a good idea if one of them appeared, or both, so we could ask questions. Well, I'd like to say to my colleague that I appreciate the idea. We've just announced our work plan, and that we will go to clause by clause. But there might be a possible compromise. We might invite these two constitutional experts to submit a brief so that we could discuss it. Well, that doesn't really suit me. I would like to ask questions.
Okay. So what I am going to suggest is that the subcommittee of PROC, who determines the agenda, has advanced our way forward. As we saw Mr. Viss refer to a document that was presented, the public is well aware of this legislation and has been providing briefs. I don't know that we need to impose on witnesses. And we did have an opportunity to invite witnesses, and we provided leniency to ensure that actually the witness that we had today was after the deadline, and we actually took another one that Mr. Viss had recommended, who declined. So on that point, I would like to say that we are going to continue. I know many people are watching this testimony and this committee. I understand we have the highest ratings, so I'm sure that the two names that were mentioned will be able to consider if they want to submit documents. And I would just say to anyone watching that the clerk would love to have any documents presented to committee for members to consider. But on Thursday, we have committed to continue, starting clause by clause, and that is how we will proceed. But Mr. Therrien, I always enjoy your suggestions and the fact that we can always find compromise in the way we work forward. Have a good day, everyone. Thank you.